So, good evening and a very warm welcome to one and all. On behalf of IPNet, the Southern region, I welcome you all to today's webinar on the topic the IBBI discussion paper on template declaration of beneficial ownership. And also, yesterday, one more discussion paper is being introduced on the amendment to the valuations. So, we'll just take a brief overview on that. And also we have one more topic, that is RP's report under section 99 under personal insolvency process, do's and don'ts and judicial precedents. So I request Mr. Shawant to kindly deliver his welcome address.
Thank you, ma'am, and a very warm welcome to all the members of IPNet who has joined this webinar today. So, good evening, everyone. I am delighted to welcome you all in today's webinar on latest IBBI discussion paper and personal insolvencies, RP's report, do's and don'ts, and judicial precedents. This is the 59th webinar in the series of webinar organized by IPNet, your own platform for sharing knowledge and experience of the IBC ecosystem in India. We are privileged to have speakers, Ms. Suhasini Ashok B, insolvency professionals, and Mr. GP Yaswardhan, who is an advocate by professions. Both are our esteemed member as well. Mr. Yaswardhan deals in IBC matters day in, day out, having rich NCLT practice, also specialized in PIRP practices. Let's have great learning on handling PIRP effectively recent times. IBBI discussion papers will be pondered and discussed. I extend my special thanks to Sri Ashish Makhija sir, who is the president of IPNet, for bringing all of us together on the robust IPNet platform. The membership link is available in the chat, and we look forward to those who are yet to join IPNet as the member. IPNet has become a vibrant community for insolvency professionals across India, fostering continuous learning, collaborations, and professional growth. We are committed to support IPs through expert-led learning initiatives like webinar and study groups, practical guidance on IBC-related challenges, and a dedicated member portal offering comprehensive resources. For those who are already part of IPNet, we extend our thanks for your support. For others, we encourage you to join this dynamic and ever-evolving network. Membership details are available in the chat. Thank you all for being here. Let's make the session insightful and rewarding.
Thank you, Shawant. So we'll have a brief IPNet video introduction about IPNet.
In the fast-evolving world of insolvency and bankruptcy, professionals need more than just knowledge. They need a strong network, continuous support, and a unified voice. As the challenges of the insolvency profession grow, so does the need for a platform where professionals can come together, share their experiences, and find collective solutions. That's why IPNet was formed. Promoted by Transition, IPNet is more than just a network. It's a mission to unite insolvency professionals across India, empowering them with the tools, knowledge, strong leadership, and community support they need to excel. Our purpose is simple: to create a cohesive community of insolvency professionals that stands strong together, advocates for their interests, and drives excellence in every aspect of the profession. At IPNet, we believe in continuous learning and collaboration. Our activities are designed to ensure that every member stays ahead in their field. From specialized study groups that dive deep into critical topics like CIRP, compliances, and many more, to webinars and workshops that bring the latest insights right to your screen, IPNet is your gateway to professional growth. Backed by Transition, a leader in insolvency training and resources, IPNet is committed to promoting the interests of insolvency professionals. Our goal is to ensure that every IP, no matter where they are, has access to the best resources, strong leadership, and a network that truly understands their needs. Join us in this mission to build a stronger, smarter, and more connected community of insolvency professionals. Together, we can overcome challenges, shape the future of the profession, and make a lasting impact. IPNet, National Network for Insolvency Professionals in India.
So we will take up the session on the discussion papers issued by IBBI. So last week we had a discussion on the recent IBBI paper on the PMLA and the affidavits which the application which the insolvency professional is to make during the CIRP process where the corporate debtors have the PMLA attachment. So last week we had two discussion papers issued by IBBI. One was on 6th November. This is the paper on the beneficial ownership, the affidavit and the disclosures to be given by the prospective resolution applicants under section 32A. So we'll discuss on that circular, as well as I just want to touch upon the yesterday's discussion paper issued by IBBI regarding the proposed amendments in the valuation, that is CIRP regulations, as well as the changing the Companies Act jurisdiction for the valuation, the applicability of the act to the empowering the IBBI. So I'll just share the screen and share the IBBI discussion paper. Hope my screen is visible.
Yes, ma'am.
Okay, thank you. Thank you for confirming. So this is a discussion paper which discusses about the template for declaration of beneficial ownership and the section 32A affidavit to be submitted by the prospective resolution applicant. So if we see the background for this, there is a interpretation section 32A compliance affidavit which the PRA is going to give. This is again in line with the section 29A additional affidavit, which is regarding the beneficial ownership of the prospective resolution applicant. If we go back to the background of section 32A, we have seen there was challenge of section 3, 4 and 10 of the IBC sections. Then there was an amendment which was brought in 2020 when in the Supreme Court, Manish Kumar versus Union of India, this section 32A was challenged. That is the clean slate and giving a clean assets to the successful resolution applicant. So if we see the section 32A, the Supreme Court has clearly given a summary of the judgment in three parts. That is from section 32A, section subclause 1 to 3, wherein the court has clearly ordered and given clarity on the abetting or conspiracy by the person who acquires the management and control of the corporate debtor under a resolution plan, which is approved under section 31 of the code. They get a protective umbrella and they get a immunity under section 32A in regard to the offenses committed by the corporate debtor before the commencement of CIRP. So it has, the order has made it even more clear if either of the conditions like abetting or conspiracy is followed, which have been mentioned in this case, then the liability of the corporate debtor for the offenses committed prior will remain unaffected. So as we all know, the significance of backdoor entry by the erstwhile promoters after the approval of the resolution plan. So to curtail this, the IBBI has come up with a discussion legal framework wherein the resolution of distressed assets should be in a time-bound manner, again giving a clear indication that the promoters or the related parties who are responsible for the stress of the company are not coming back into the through a back entry after the approval of the resolution plan. So this discussion paper is issued in compliance with the RBI master circular regarding the KYC, that is for the chapter 4 risk management assessment. So in all the related financial sector regulators, the RBI monitors the KYC. So in compliance of that, the discussion paper is issued for the comments of the stakeholders. So if we see the various important aspects here is who are what kind of disclosure the discussion paper mandates. So through this discussion paper, they have invited the comments for an amendment to Regulation 38. So as per Regulation 38, it mandates the PRA to file a statement of beneficial ownership, and now it is being formalized that what kind of beneficial ownerships has to be disclosed, and a format is being given very clearly, and an affidavit is also need to be submitted by the prospective resolution applicants. So if we see, the discussion paper proposes to make an amendment to Regulation 38, which mandates every PRA as part of the plan to disclose the statement of beneficial ownership in the format specified by the board, covering details of all natural persons who ultimately owns or controls. So you see, it is giving a clear requirement, that is ownership is also controlled, as well as ownership is to be disclosed and control also. So if anyone, if we go back, if we go down further, it gives 10% is the limit. So ownership 10% and control. So control, as we know, the definition is given under Companies Act. So it is the natural persons who ultimately owns or controls the PRA. It is together with the shareholding structure and jurisdiction of each intermediate entity. Again, even if through intermediate entities also, whatever is the relationship, it has to be disclosed. And the affidavit in the format which is again prescribed by the IBBI, the PRA has to submit the resolution plan. So if we see the draft format of the beneficial ownership, it gives when the beneficial ownership shall be construed in accordance with the meaning assigned to it under RBI Master Directions, which was recently updated in August 14th, 2025, wherein they have to know, this is a master circular regarding the updation of KYC. So here they want to know your client. So here even the resolution plan, in the resolution plan also, the KYC of the person proposing the plan has to be disclosed. So if we see the format given, it is very clear that the beneficial ownership of the prospective resolution applicant, the legal form, that is company, LLP, trust, or any other form also, they have to give the ownership if they are owners of any of the companies or LLPs or trusts. Then country of incorporation, registered office address, then all these details format is being given. And one important thing is about the applicability of this disclosure in case of a listed entities and their subsidiaries, since the listed companies LODR requirements, they give the disclosure, so it is not mandatory for them. So they have to give the link of the reference of their public filings. So while giving the declaration about the beneficial ownership, they have to give the link of whatever they have filed with the stock exchanges. And they have to give the ownership structure and capital structure, whatever the component. And one important thing is, if you see the point number part 3.B, one important thing I want to highlight is ownership and control structure. So here the PRA is supposed to, if you see the note here, it says attach an organizational chart ownership diagram showing the entire control. So the complete control chain of and the organizational chart of such beneficial ownership has to be disclosed. And if we come to the draft format of affidavit, there are many questions actually which come to us when we are practicing. That means whenever the PRAs are submitting, is the affidavit valid till the plan is approved, or is it valid till the company is in existence after the SRA acquires the company? So if we see the affidavit format, it says I am duly authorized. This is a standard format that the PRA has submitted a resolution plan in respect of the corporate data. Declare hereby that prospective resolution applicant is eligible or not eligible to claim the benefit of 32A on the following basis. So here the PRA is demonstrating his eligibility or ineligibility. He is affirming on the affidavit. So again, he at fourth point also, he is confirming none of the persons who will assume management or control is a person ineligible. So they are also declaring the persons who will be assuming the management post approval of the resolution plan that they are not ineligible persons under 32A. So this is again in compliance of regulation 38 they are giving. So I'll keep the questions open for discussion. After our second speaker session, we can have discussions on the discussion paper on beneficial ownership. And I just want to touch upon the one more discussion paper which was issued just yesterday. Hope my paper is, my screen is visible, sir. Someone
Yes,
can
ma'am.
confirm?
Yes, ma'am.
Thank you. So yesterday, the discussion paper on strengthening the valuation process under IBC was issued. There are many amendments which the IBBI is proposing. So practically, we need to see how things are going to evolve. So I'll just take a few highlights of this paper and we can discuss post our second speaker session. So this is again, as we all know, the valuation is one of the critical process in the CIRP as well as the liquidation process, pre-pack or in any processes under IBC, because the valuation is the base on which the COC takes the decision on the resolution plan submitted. So during the past 10 years, the IBBI has noticed that valuation reports and during the processes, they have been inconsistent, and even there was no comparability between the two valuations and how the methodology adopted. There could be different methodologies adopted by two different valuers and how the value is determined. So seeing few issues, there were few lacunae which IBBI and the stakeholders felt. So this discussion paper is being issued and it is open for the public comments. So I just highlighted few portions of the paper wherein I can just touch upon. So one is the IBBI want some documentation which has to be maintained along with the valuation report by the registered valuers. That format will be specified by the IBBI. So they are going to issue a amendment and also circular the format which the valuation reports have to be how the standard valuation report formats will be prescribed, and the background papers documentations have to be saved by the valuers. And earlier, the internationally accepted valuation standards and the company's registered valuation and valuation rules were applicable. But however, different methodologies were adopted. Hence, IBBI felt it is better that they will come up with a valuation standards which has to be adopted by the registered valuers organization. So as a proposed solution, now harmonized valuation standards will have to be adopted for conduct of the valuation during any processes like CIRP, personal insolvency, pre-pack insolvency, liquidation or bankruptcy process regarding the personal guarantors matters. And also IBBI is proposing to amend the sub-regulations under regulation 35 of CIRP, then again bankruptcy process regulations and fast track insolvency process regulations. Here, the fair value, when the valuers were giving the assigning the fair value as on CRP commencement date or as on liquidation commencement date, the definition was again the different valuers used to take the different uh, applicable rules or the formulas. So to have a comprehensive unified valuation on the fair value, IBBI is proposing for the revision in the definition of the fair value. Again, we see practically for the companies which are small sized corporate debtors, to reduce the cost and burden on the stressed asset CD or the creditors. Now it is proposed to appoint a single registered valuer for small sized corporate debtors. There is no requirement of there will not be requirement of appointment of two valuers for each category of the asset. And now the IBBI is proposing for appointment of a coordinator valuer to estimate fair value of the CD. So earlier we know that three categories of assets, we need to appoint to each category. That was 6 registered valuers for 3 class to be appointed. So now the IBBI is proposing for only appointment of each asset category, one valuer, and overall a coordinator valuer will be appointed in case if there is a deviation between two valuation reports, that is 25% deviation between two valuers, they are going to have a coordinator valuer. So these are the just brief summary points I thought I'll just share with all of you, and we can open the floor for discussion after the second speaker session on the beneficial ownership as well as the proposed valuation regulations which IBBI is proposing. So thank you. Now, I invite Janvi to kindly introduce our next speaker, Mr. Yashwardhan, and also about the topic. Janvi, are you available?
Yes, ma'am.
Yeah.
So, our next speaker is GP Yashwardhan, who is the associate partner in India Law in the Hyderabad office. He is an integral part of the dispute resolution team of the firm. His prominent areas of practice include insolvency and bankruptcy, debt recovery, civil litigation, commercial litigation, and consumer redressal issues. He regularly appears before the High Court of the Telangana and NCLT civil courts, consumer forums, arbitrational tribunals, DRT, labor court, and the quasi-judicial forums and authorities. He represents bank and financial institution, COC members, RP, and liquidators before the NCLT in matters relating to the insolvency and bankruptcy code. So I'll welcome GP sir, GP Yashwardhan sir, to continue and take the session.
Thank you, Janvi.
Thank you, Janvi.
Yeah.
Hello, everyone. I'm GP Yashwardhan. I'm glad to be speaking with you all today. I've been, like Janvi said, I'll be working on insolvency and bankruptcy matters since its inception. And over the years, I've seen how the subject has evolved, in terms of strengthening the India's ecosystem. And I personally feel year 2016 and 2019 are very important, with the launch of CRP framework in 2016 and introduction of PRP mechanism in 2019. So in today's webinar, I will be focusing on section 95 to 100 of IBC, which deals with insolvency process of individuals and partnership firms. I'll be particularly focusing on insolvency and resolutions of personal guarantees to the corporate debtor, and also the key do's and don'ts of the resolution professional in its reports.
Sir, yeah, our PPT is visible to you? Yes, sir.
Yeah, it is visible. It is visible. Thank you.
But not moving. Yeah, now it's moving.
Yeah,
Okay,
yeah.
okay, sir. Thank you.
Yes. Yeah. So before the introduction of IBC, we had Presidency Towns Insolvency Act and Provisional Insolvency Act. You must be aware that it has been repealed and now it's been consolidated into IBC. So the basic objective of the IBC would be like time-bound process and ensure that the accounts are resolved, and also ensuring that the balance is maintained between creditors recovery and also the debtors protection. So this particular provisions apply to the debtors and personal guarantors of the corporate debtor, which basically covers two aspects of it. One is insolvency resolution process, personal insolvency resolution process. And the second part of it is bankruptcy process when the insolvency resolution process fails. It is pretty much similar to what we see in the corporate insolvency resolution process. As far as the insolvency resolution process for the personal guarantors are concerned, the adjudicating authority is Honorable NCLT, that is National Company Law Tribunal, which has jurisdiction to preside over these matters. Because usually what happens is, as per Section 60, wherever the applications of the corporate debtors are pending, though it is ARP or liquidation, the proceedings against the personal guarantors will also have to lie before the same tribunal. So therefore, initiation of proceedings would be before the concerned NCLT, where either the CRP of the company is pending or the liquidation. Irrespective of this, also where the registered office of the company, that is a corporate debtor, the personal insolvency proceedings will lie before the same court. Yes. Can you come to the next slide, please? Now, this is the process which basically involves the personal insolvency. What triggers the insolvency resolution process is only two, be it under the Section 7 or Section 9 or Section 95, that is, there should be a debt and there should be a default. Without establishing these two facts, which is a condition precedence to trigger these proceedings, there cannot be any proceedings. So what is first, which is important, is there should be a debt and there should be non-payment of the debt when the default occurs. Second condition for invoking the personal insolvency before NCLT is to service of the demand notice. So without servicing the demand notice, there cannot be an application which is maintainable, because I have now seen so many applications being filed where the preliminary objection would be maintainability, saying that the demand notice was not served. Demand notice was not served to the address which is mentioned in the guarantee agreement, or demand notice is addressed to some other address where the creditors have auctioned the property and the guarantors are not residing in that property. So these are the very important critical aspects that needs to be looked into. So next step is once the notice is served, then the application will have to be filed. That is either under section 95, the application will be filed. Section 94 is an application where the debtor or the guarantor voluntarily uh, proceeds or invokes the jurisdiction of IBC and files an application before NCLT for initiation of insolvency resolution process. This is similar to section 10, where the company approaches the honorable NCLT. As far as 95 is concerned, section 95 can be filed by the creator itself or through a resolution professional that I'll come to the next slide. Once the application is filed, the interim moratorium kicks in. Can you just come to the previous slide, please? Yeah, section 95, section 96 moratorium will kick in. Basically, the section 96 will have to be looked into in a way that it basically protects the creditor. It is not against the creditor, because once the interim moratorium is declared, no proceedings can be allowed or permitted to be initiated against the guarantors. So this particular process of 96, and the next step is appointment of the RP under section 97 and 98. So once the RP is appointed, then the RP will basically coordinate with the debtor and creditor and ensure whether there's any debt has been paid or not paid. Then an examination is done and then a 99 report is filed. Then the next step would be the Honorable NCLT, upon receiving the 99 report, will give an opportunity to the guarantor and also the creditor, and the application will be finally decided under section 100. The next step, please. Next slide. So these are the two landmark judgments. That is the first judgment, that is Lalit Kumar Jain, where the constitutionality of the IBC provisions have been challenged. The Honorable NCLT has upheld that the provisions are valid. The second judgment is Dilip B. Jivarka versus Union of India. This particular judgment I'll be dealing with in subsequent slides. So next. Yeah, this section 94, like I said, this is an application which can be filed by the personal guarantor for invoking the jurisdiction of the personal insolvency by filing an application before NCLT. The second slide, please. Yeah, so this is basically disqualification, that who cannot invoke the jurisdiction. That is an undischarged bankrupt, anyone undergoing fresh start process, undergoing insolvency resolution process, or undergoing bankruptcy process, or 1 year has not been completed since the previous admission. Here, the judgment that I've quoted here, that is Ramesh Kothari versus State of MP. Here, the Honorable High Court has held that the sole proprietary concerns will not fall under the definition of section 3 subsection 7. Therefore, they cannot invoke the jurisdiction under 94. The next slide, please. Yes. So this is a section 95 application filed by a creditor to initiate insolvency resolution process. This is basically a creditor can singly or jointly or through a resolution professional may apply for insolvency resolution. For partnership debts, the creditor may proceed against one or more partners of the firm, or multiple applications in respect to the same firm can be consulted. The important is procedure for invocation. That is, application must state the details. There is a proof of debt and non-payment of debt within 14 days from the date of service of the demand notice. The term service is very important. Then the application has to be served on the debtor, and the same has to be filed with the prescribed fee. The next slide, please. So this is very important. So what usually needs to be looked into to see whether the notice has been duly served under the IBC is, as per the insolvency and bankruptcy application to the adjudicating authority rules of personal guarantors 2019. So basically it says that any service, so these rules 3G says that the service includes sending any communication by registered post, speed post, courier, or electronic means capable of generating an acknowledgement of receipt. Now, what I've observed in most of the cases that have handled, it has been reported to the NCLT that the notice has been served through mail. So just by sending a notice through mail will not suffice. That particular email which contains the notice should be able to generate an acknowledgement of receipt. If that is not done, then it is not sufficient service of notice. Assuming there is a notice that has been sent, it has been returned, then what is the next way of doing it? That I will come to that in my subsequent slides. So before filing an application under Section 95, creator must serve the demand notice in Form B for the guarantor demanding the payments of default. And the copy of the application in Form C must be served forthwith upon the guarantor after filing the application. So basically the serving of the copy to the guarantor, it is not a condition that only after service we have to initiate the filing of the application. Even after filing of the application, the notice can be served. So basically what is be done is once the application is filed, simultaneously an application is also served on the guarantor. It is not a case where you have to first issue and serve the notice and then file the application, unlike a demand notice. Can you come to the next slide, please? So these are the procedural compliances. So proof of service. So creator must basically serve the notice. So this is a case where in SIDBI versus Arjav Mahesh Bhai Patel 2020 for SEC, this particular application was dismissed for non-compliance. So this was a case where only the recall notice was issued, but the postal receipts acknowledgement that has been served on them was not filed. On this ground alone, the application was dismissed. So second would be affixation and electronic service, which I've already covered in my previous slide. So what basically happens is, if you can, assuming usually there will be a cases in the personal insolvency that in the guarantee documents, only the address of the guarantor will be mentioned. So usually this would be assuming there is a guarantee agreement which is executed, a couple of years back, and now you want to invoke an application or invoke the jurisdiction of the personal insolvency. There may be instances where the guarantor may not be residing in that address. So what basically happens is alternative service, assuming they provide their email ID in the CIBIL records. You have the CIBIL records. So you issue the notice. If it is returned, the alternate is you can serve it through email, where you can get the delivery of receipt of proof. If this is also not available, then what needs to be done is affixation of the notice at their residence. That is also allowed under the rules. So once it is established that the notice has been affixed at the outer portion of the residence of the personal guarantors, then it is presumed that the notice has been served. So next is the deemed service. There are instances where the notices are served, it is returned unclaimed or undelivered. Then it is presumed that the notice has been served and the application can be proceeded under Section 100. So this particular judgment of Central Bank of India was Usha by another, which clearly says that if the notice is served, if it is undelivered, if it is unclaimed, and if it is sent to the last known address of the guarantor, then it is deemed service. And one important and very peculiar case, in fact, that I have handled is subsequent invocations. So assuming there is a case that we have invoked, there is a recall notice that is issued and the recall notice is returned, or the recall notice was issued and subsequently a creditor comes to a conclusion that the earlier notice that was issued, there were some discrepancies. So for a creditor to file an application under IBC, there should be an invocation of the guarantee. That is a condition precedent. So what happens is sometimes the notice is issued, then the creditor comes to a conclusion, there are some issues with respect to the earlier notice where there is a discrepancy. That earlier notice, probably the amount that is mentioned is not accurate, or the loan agreements have not properly captured. Then the creditor issues a subsequent notice superseding the earlier notice, which basically says that this notice is issued afresh. So what would be in those circumstances, maybe the adjudicating authority will come to a conclusion that the first notice will be a notice of recall or invocation, that has to be triggered for the purpose of limitation. So this particular judgment where the Honorable NCLT has held that in the subsequent notice, if you're able to establish that there is some kind of a discrepancy in the earlier notice and this notice has been issued say capturing the latest incorporating the latest details, then the subsequent notice has to be considered because it is a continuing guarantee. So can you come to the next slide, please? Can you please share the next slide?
Can you okay. There was network issue.
No problem, no problem. I can't see the next slide. Yeah. So this is the next aspect because all the in most of the personal insolvency cases, the only objection that usually is being raised is with respect to the limitation, saying that the application is not within the limitation, it's barred by limitation from the date of default, it is more than 3 years. So there are three ways of doing it. One is from the date of default, you have to file within 3 years, an application has to be filed. If there's an acknowledgement, the limitation extends. And secondly, if there's any recovery certificate that has been issued within 3 years from the recovery certificate, application can be filed. Because all these factors have to be looked into because at the time of examining the report under section 95, because RP has to examine all these aspects, whether it is within the limitation, whether the debt and default has been established, and then examine the report and then file a report before the adjudicating authority. And the second aspect also usually that is permissible is with respect to the COVID limitation where the court has excluded the period for limitation from 15 March 2020 to 28th February 2022, which basically says that if any period, even any limitation is falling within this period, the same can be excluded. So once the period is excluded, the remaining period can be included or rather the remaining period will be extended. So this will basically help for the purpose of limitation. Can you please come to the next slide, please? And this is another important practical issue or rather an issue that I've handled before the court. So basically what happens is the section 95 applications can be filed by a financial creditor where the financial creditor will file an application. Usually the name of the insolvency professionals to act as a resolution professional is not usually proposed. But if it is proposed, it's a different issue because usually in practically what any creditor usually does is even if even there's no provision to propose a name of a creditor in the form, they usually mention that they're already proposing an insolvency professional, and usually the court considers it and it appoints it. In the cases where an application is filed through the resolution professional and the resolution professional is also submitting a report under 99. So this regulation 4 sub-regulation 2, it says an insolvency professional other than who has filed the application under section 94 and 95 on behalf of the guarantor or a creditor as the case may be shall provide a written consent in form A to the adjudicating authority before his appointment as resolution professional in the resolution process. So the person filing the application other than him, another IP should be giving his consent so that there will be some kind of a transparency. But this particular judgment of Honorable NCLT and Ravi Ajit Kulkarni has held that Section 97 does not prohibit the adjudicating authority from appointing the same resolution professional who has filed the creator's Section 95 application. So basically, it tells that there is no statutory bar on such particular appointment, and RP submits an application may validly be appointed because basically what the observation of the Honorable NCLT was, it is a court appointed. He will have is empowered to give and is also bound by the rules and regulations. Therefore, there cannot be any bias while submitting the report. Can you come to the next slide, please? So these are the ingredients under the interim moratorium. So interim moratorium commences automatically on the date of filing of an application. So during this period, all legal proceedings will be stayed and creditors cannot initiate new proceedings, and the moratorium will extend. The only important difference that you can point out in this interim moratorium is usually that this particular provision will basically safeguard the interest of the personal guarantor, but it is not something that is, as a creditor, as the guarantors usually claim, is against them, because here their right to alienate their assets and deal with their assets have not been prohibited or restricted. That is a very important, difference in this particular provision, unlike Section 14 moratorium under CRP. Can you come to the next slide, please? However, this particular proceedings, this particular provision is not, the criminal proceedings are not exempted. So this will continue. The next slide, please. So these are basically the appointment of resolution professional, where the application is to be filed by RP through RP. NCLT directs the IBBI within 7 days that no disciplinary proceedings are there. Then IBBI must in 7 days confirm the RP's appointment. And where the application filed by the RP filed is without RP, NCLT will direct the IBBI within 7 days to nominate, and the IBBI should nominate within 10 days. Then NCLT then appoints the RP recommended or nominated by the IBBI. So this particular judgment which I am referring here, that is L. Ramalakshmana was a State Bank of India. There was a particular objection which was raised here, which says that the word shall used in Section 95 is mandatory, and it should not. It should be strictly followed by NCLT before appointing the RP. So the Honorable NCLT has held that Section 97 is directory and not mandatory, and it does not oblige NCLT to await IBBI confirmation for appointment, because this being a time-bound process. Can you please come to the next slide, please? This is Section 98, basically replacement of resolution professional. This basically either the debtor or creditor may apply for the adjudicating authority to replace the RP. Then the procedure was that IBBI NCLT must request IBBI within 7 days, and they have to respond within 10 days. And the creditors may also collectively decide to replace the RP during implementation. If NCLT admits the replacement request, it must direct IBBI to again confirm if there's any disciplinary proceedings against the said IP, and IBBI must confirm within 10 days, and NCLT will thereafter appoint. So NCLT again in this particular matter interpreted IBC that subsection does not specify any limit or ground on which the debtor or creditor may seek replacement, and if sufficient reasons are provided, then the IP can be replaced. Then the next slide, please. This is a very crucial section, I would say, because this is basically a backbone of the entire personal insolvency resolution process, because this is where the insolvency resolution professional will examine the application that has been filed and discuss with the creditor and the debtor, and to ensure whether the debt has been paid or it is not been paid, and then a report is then being filed before the adjudicating authority after following the provisions and the rules of the code. So first, what basically is required is the RP must examine the application to submit a report within 10 days. So in the creditor initiated cases, that is Section 95, RP may require the debtor to prove repayment. If the debt is registered with information utility, the debtor cannot dispute it, and the RP may call for further information from any person, and the same shall be furnished within 7 days. Then RP must verify the application to meet the requirements under Section 99, subsection 6. And also, very importantly, satisfy the requirements under Section 95. This is very important, because what it means that to satisfy the requirement of Section 95, because an application which a creditor files it, it is a duty of an RP to examine whether the application is filed in a proper format, whether there is a debt that exists, whether there is default that has been committed by the principal borrower, and pursuant to default that has been committed by the principal borrower, whether the guarantee has been invoked as per the terms of the guarantee agreement. If the guarantee is invoked as per the terms of the guarantee agreement, whether the terms of the guarantee agreement, if it says that the guarantee amount has to be paid on demand, whether the demand has been made by the creditor, and that particular demand, whether it is been made in a prescribed form or format that has been mentioned in the guarantee agreement, because it is a contractual document, so that it has to be strictly followed by the creditor. And very importantly, usually what I've seen in many cases, that the guaranteed amount is usually restricted to a particular amount, and sometimes the guarantee is only provided to the extent of a property. In some cases, even after the property has been sold by the creditor, and knowingly or unknowingly a section 95 application is invoked based on the guarantee agreement, and the objections being raised that the guarantee is only to the extent of the property, nothing remains. So these are the very important aspects that have to be looked into at the time of preparing the report, because we have to basically see what is the terms of the guarantee, what are the liability of the guarantor, and what is the amount of the guarantor that has been guaranteed under the guarantee agreement. And other aspects where I've seen is, assuming for an example, the guarantee amount is only for 100 rupees, for an example, hypothetically speaking, but the claim is filed for, but the principal amount is filed for 150 rupees. So these are all the objections which usually, sometimes it's when the application is filed, application, the guarantee agreement may not be looked into properly, and the creators file the application due to an oversight. But it is the RP's duty to ensure that all this is being captured in the report. Then whether the application is filed within the limitation, whether the recall notice that has been sent to the guarantor invoking the guarantee, whether it has been served on them, whether the creditor has filed the recall notice, the postal receipts, the tracking report to show that it has been served on them, and whether the invocation is according to the terms of the contract, terms of the guarantee agreement. All these things have to be looked into. And from there, whether the application is within the limitation from the date of invocation. There's slight difference in this because an application filed against the principal borrower will, in case of default, it has to be filed within 3 years. But as per the Supreme Court judgments, which basically says even just before the creditor's claim against the against the principal borrower expires, if an invocation is done, then the creditor will get an extended period of 3 years to proceed against the guarantor. So basically, what has to be looked into is whether the limitation period, which is a very crucial aspect, because a debt claims cannot be revived. That is the basic idea behind it. So that has to be looked into. So even any communications that has been done, because I've seen in a couple of reports where any communication after the appointment of RP under 99, they are sent to the debtors, and they are not properly addressed to them. And in the report, they say that the notice has been sent to the debtor, no response has been received. But what I see is there is no proper proof to say that it has been actually communicated. So this is very important, because these are the objections which have been categorical objections which have been raised by the guarantors during the admission under section 100. So all these aspects are very important and crucial to see whether there is a debt, there is a default, whether it has been invoked properly, whether it is within the limitation, whether the recall notice has been served, whether demand notice has been served, whether demand notice under IBC is in a proper format, whether it has been sent to the correct address which is mentioned in the guarantee agreement, or whether it is sent to some other address, and whether it has been served. All these aspects have to be very thoroughly checked while examining the application under 95 and filing the report under 99. Can you please come to the next slide, please? So these are certain judicial interpretations and citations that I would like to share with you all. The first one is Ravi Ajit Kulkarni versus SBI. So basically, this particular judgment says that the 99 subsection 2, which says that evidence of electronic transfer of unpaid amount from the bank account holder will be sufficient evidence. Evidence of encashment of a check issued by the debtor will also be a sufficient evidence, and signed acknowledgement by the creditors accepting the receipts of the dues. So there will be instances where sometimes there will be an acknowledgement of debt. Once there is an acknowledgement of debt under section 18, usually in all the banking transactions, the acknowledgement of debts are usually done by way of a revival letters, or by way of balance confirmations, or by way of a one-time settlements, which are usually given by the debtors by the creditors. And what is importantly that needs to be looked into is there are a couple of instances where the objections have been raised by the guarantors that the acknowledgement has been done by the principal borrower, therefore it is not binding on the creditor. The Honorable Supreme Court has very clearly held, once the terms of the contract is clearly captures that any debt confirmation by the principal debtor is binding on the guarantor, then the guarantor cannot take an objection that it is not binding on them. It is, once the debt is acknowledged by the principal borrower, it will definitely be binding on them, and this amounts to an acknowledgement of debt by the guarantor. The second judgment is Miss Ella Tenney versus State Bank of India, which basically this order says consequences of improper Section 99 report. This is very important. NCLT has criticized RP for failing to disclose material facts, including allegations of fraud and contempt. The order reaffirmed that the RP must bring all adverse information to NCLT's attention rather than submitting a superficial or incomplete report. So this is also a very important judgment. The third judgment is Suresh Atlani versus Omkar Asset Reconstruction Company. It's a 2025 matter, which basically says that tribunal held that the scheme delineated under section 95 is clear that submission of report within 10 days from the appointment of RP is only directory. It cannot be held to be mandatory. This is a settled law because it's only a procedural aspect. The third judgment is the report, the Iqbal Ujamboy versus Manoj Kumar Anand. It says that the RP report is purely recommendatory and not adjudicatory, and it is solely meant to facilitate the transition to the stage of section 100, where the acceptance or rejection rests exclusively with the adjudicating authority. Can you please come to next slide, please? No, this is a very important judgment of Honorable Supreme Court, where the primary objection that has been raised is that when an application under 95 is filed, or any application invoking the insolvency residual process is filed, the adjudicating authority appoints an RP without there being given any opportunity to the guarantor to be heard. So basically, this particular judgment also laid down what is the role of the insolvency professional once it is appointed by the adjudicating authority, and what needs to be looked into by the resolution professional while the report has been filed, and what are the important aspects that needs to be looked into. The first is the RP cannot decide the issue in the absence of the opportunity to the debtor to furnish an explanation and to produce material evidence of the payment of the debt. And because RP has to ask for the information, and the opportunity will definitely be given to the resolution to the personal guarantors. So what the Honorable Supreme Court basically held in this particular matter is, even after the once the RP is appointed under 99, the RP will engage with the debtor. Therefore, the question of there not being given an opportunity to be heard does not arise, because he will basically ask the guarantor whether the amount has been paid. If the amount has been paid, please provide the information. So therefore, the application that has been filed by the creditor, the RP once appointed, definitely will be engaging with the debtor. The second one is the information sought by the RP must be relevant to the examination of the IRP. This is very important. The IRP cannot go into the roaring inquiry. The IRP should basically restrict himself to the application that has been filed, whether the application that has been filed satisfies section 95 and it is in correct format. All the ingredients are satisfied and established by the creator. Second, thirdly, what is very important is the RP should, whatever information is being provided by the debtor should be confidential, should not be disclosed. And it is only to be kept to himself, and whatever needs to be informed, reported, that has to be reported and included in the RP report. Then fourth very important aspect is in this particular period, while RP is filing a report, RP does not has any adjudicating authority powers. RP only has to examine the report, examine section 95 application and see if it is in order, collate all the information and then file a report before the adjudicating authority, recommending whether the application has to be admitted or rejected under section 100. The next slide, please. So these are basically very important points that has to be looked into while submitting a report by the RP. The application has to be examined very carefully and prepare a reasoned report. See, whatever points that I've captured before, like have to look into the loan agreements, sanction letters, and then to see whether the guarantee is properly executed by the persons, whether the notice whether there's a debt by the principal borrower, then there's also a default committed by the principal borrower and also the guarantors. The notice has been invoked, served on them, then I notice under IBC has been served on them, and requisite fees has been paid by the creator in filing the application. Application has been duly served on the guarantor after filing the application. All these aspects have to be looked into, and in also whether there is any debt and default, whether there is whether the debtor is admitting that the debt has already been paid. If the debt is already been paid, whether the debtor has provided, the guarantor has provided any proof of payment of debt. All these things have to be very carefully examined. And the second point, collect the proof of debt payment or non-payment of the debtor under 99 subsection 2. Usually the RP can also ask for further clarification. A classic example that I would point out would be, now there is an application that has been filed under section 95 and the statement of account is not filed by the creditor. Then the basis for filing an application would be on a statement of account where they show that the outstanding amount, or whether the notice has been issued, the tracking report is not filed, for you to come to a conclusion whether the notice has been filed. So these are the information that you can still go back and ask. And once that is filed, then you can examine those documents and then file a report before the court. Then apply threefold test of legality, legitimate aim and proportionality. So these are basically speaks of keeping confidence, ensuring that the entire process is done correctly in a legally manner, and ensure that everything is in everything is properly captured in the report. And the next is ensure compliance of service of demand notice to the creator that I have already covered. Independently verify disclosures and material facts to ensure bona fides of the debtor. This is very important. So basically what has to be looked into is whether all the aspects have been covered and there exists a debt and default, and there is no discrepancies in the application filed by the creator. All these things have to be looked into. Do not ignore adverse facts concerning the fraud or contempt, which the judgment that I've just showed to you, which basically covers that the RP has to look into all the aspects, but ensure that it is restricted to the application, but ensure that all other aspects are also covered. Because the intent of filing an application is to resolve the account, because IBC is basically introduced to revive and resolve the accounts, but not merely a recovery mechanism. The next is do not convert an examination into an adjudicating process. Then you cannot sit as an adjudicator and decide as an adjudicator, because that is a duty or a job of a honorable of the NCLT in section 100, while deciding the application under section 100, whether the adjudicating authority will see whether the report that has been filed under 99 captures everything, and after hearing the personal guarantor, giving them an opportunity to be heard based on the report that has been filed by the personal guarantor, then it is a duty of the NCLT to adjudicate the entire process. So do not seek information unrelated to section 99 report that has already been covered, and do not breach the confidentiality or privacy of the parties while gathering this evidence. So these are the very important points that needs to be looked into at the time of preparing the report. The next slide, please. So under section 100, now the NCLT within 14 days of receiving the RP report, either admit or reject the application. In all honesty, it usually doesn't happen, but we all try our very best to get it admitted. But because of the pendency of the application and a lot of postings of the matter, this usually doesn't happen within 14 days. And upon admission, it may direct negotiation with the debtor and the creditor to frame repayment plan, and the NCLT will also circulate its orders to the RP's report within 7 days. If rejected, if the application is found fraudulent or malicious, the creditor may proceed again for bankruptcy under Chapter 4. So this judgment I've already covered earlier. So basically, the Honorable Supreme Court has held that the adjudicating authority in this section must actively engage in fair process, affording the debtor a fair opportunity to present their case, and should arrive at the determination by considering the arguments supported by the relevant material particulars. In essence, the adjudicating authority conducts an independent assessment, not solely relying on the RPA report to decide the fate and applications under section 94 and 95. So basically what this judgment says is the adjudicating authority, we cannot solely go by the report and do a mechanical job. The adjudicating authority should again go into the merits of the matter, see the adjudicating authority should go above and beyond the RP report and see that section 95 application is or an application is filed according to the provisions of the code and rules, and the objection that has been raised by the personal guarantors has also been addressed, and then a reasoned order has to be passed under section 100. So this is the key points that needs to be looked into at preparing a 99 report. Thank you for a wonderful opportunity. It was a genuine pleasure.
Excuse me, sir,
Yes.
one clarification.
Yeah, please.
This bankruptcy application, once the repayment plan is got rejected, now RP will submit a report. RP did not, ask for bankruptcy, correct? Only duty of the RP is to submit a report on rejection of repayment plan with voting sheet. Only
Correct.
the financial creditor or the debtor, they only has to make further application for bankruptcy. Correct, no, sir?
Correct, correct. So usually what happens is, what I see in all the RP reports is the RP usually requests the Honorable Tribunal to close these Section 95 proceedings and permit the creditors to file an application. So that application will have to be filed within 3 months from the date of order. Now, it's a settled law that the 3 months timeline is also not mandatory. It is condonable. In fact, I myself have handled a matter where the Honorable NCLT has condoned the delay, saying that it is only directory and not mandatory, for a fact that under section for 121, the outer limit is not being provided, unlike section 61, where the appeal will have to be filed within 30 days and another 15 days is granted, and beyond that the court cannot extend the period for filing an application. However, in this in 121 application basically says even beyond that also it can be filed.
That order from the NCLT itself is coming belatedly, sir. After
So
2 months, sir. We are not aware of when the order has passed. Only the counsel of the applicant, debtor, no, they are calling and saying that the order has got already passed. So they have each and everything, receipt of the order as well as delay in, rejection of repayment plan, no, that also the financial creditor coming back after 1 month. So this delay and all, it's not because of the default from the side of the RP. It is a default from the side of one in the case of NCLT and another by a financial creditor. So, already for the doing this process, no payment from the financial creditor is taking late. So they are not making the payment. So once again, continuation of application, we cannot incur expense, no? So we can do consolidated single application, no? I mean, for rejection of repayment plan, we are filing one IA. In the same application, we can ask for the continuation of delay also, correct?
Yes, you can ask. See, because see,
Mm.
ultimately it is a discretion of the court. If any condonation, if you are able to give reasonable justification as to why there is a delay, and delay is not on part of the insolvency professional, but through an external factors that which is beyond your control, then the court will definitely condone the delay. See, because under Rule 11, court will definitely have discretionary power. But if a statute provides for a particular timeline, but you cannot just mechanically invoke Rule 11.
The repayment plan once got rejected, we not need to go back again to the sender debtor to go or to give a improved repayment plan.
Not required, not required,
RP has
because
no right. No?
you have to complete the process within the timelines. You cannot go
Okay.
back. Because in fact, now I've been in my practical experience, I would like to share. Certain tribunals are not even encouraging the IPs to file non-cooperation applications. What they're saying is if the guarantor is not coming forward to submit a repayment plan, you cannot force them to come. So you just proceed further because the non-cooperation applications are being pending for quite some time. And then the RP is again filing a IA for extension. But under the there is no provision for extension of period, unlike CRP. Those are peculiar issues that we are facing now. In fact, I handled one matter yesterday. I was in the court, and Honorable NCLT said, "Where is the provision for extension of time?" So you have to strictly follow the provisions. If there is no, if either the guarantor or the creditors is not cooperating, you have to strictly go by the provision. You have to go and do the next step that is mandated under the code. You cannot sit because ultimately the responsibility will fall on you. The court will ask you. It will not ask the creditor or the guarantor. It will ask the IP what they have been doing.
Okay. Thank you, sir. Thank you.
Welcome.
Sir, good evening. This is Balasubramanian. I have a question for you. Actually,
Yes.
in case of limitation,
Hmm.
so in one case, the DRC has been issued by DRT. Within 3 years, the financial creditor has invoked, say, issued Form B in the demand notice under, so demand notice under IBC. So, from the date of issuance, they are saying that within 3 years we have invoked. So within but 10 days they have to make the payment. So 15 days. So from the date of default is calculated from the 15th day, which is false from the date of issuance of Form B.
No.
Can we take it
See,
as?
no. Because there is a judgment which basically says is a notice issued under IBC cannot be a recall notice. Okay. There
Okay.
should be a recall notice prior to that, because now if see basically any proceedings where an application is filed based on recovery certificate, because I have handled probably quite a lot of matters under RC. The moment you receive an RC, you will get 3 years from the date of RC as per the Dena Bank judgment and Kotak Mahindra judgment. So your cause of action will start from 3 years from the date of receipt of the recovery certificate. But sometimes what is happening by the creditors, the moment they receive a recovery certificate, they say the debt has been crystallized. So the debt and default is established. I can file application within 3 years. So from the date of receive of recovery certificate, we are issuing a notice under IBC and then proceeding to file a 95 application before the NCLT. When the application is filed before NCLT, what the court is asking is, I agree there is a recovery certificate in your favor, but have you actually invoked the guarantee? You got my point?
Yeah, sir. We say that Form B issued is a invocation of
No, that cannot be.
guarantee.
That is not.
Yeah.
There is a latest judgment which says that IBC invocation cannot be construed as a recall notice.
Okay. It is
That is
only a
not.
demand notice.
It is only a demand notice. So your
Demand notice
recall
also
notice
will be
should be prior to IBC notice.
okay, sir. Okay.
But see, technically, once you receive a recovery certificate, it is assumed that you've invoked the guarantee. Okay.
Yes,
But
sir. Yes.
in instances where the guarantors, where the corporate debtors or the guarantors remain ex parte, then they may
Yes.
come and challenge that no, I was never served a notice, because neither the order says that notice has been invoked, notice has been served on
Yes.
me. Now the recovery certificate is not been recovery certificate cannot be looked into for the fact that the guarantee was never invoked.
Yes,
And if
sir.
you are not able to,
Yeah, one more thing, sir. If it is in case of a continue, it is a guarantee executed by them is a continuing one. Can we say that even after expiry of 3 years from the date of DRC, can we say that still the limitation period is available to invoke?
no. See, 3 years limitation, you may have a remedy, okay, but you don't have a right, because your right expires after 3 years.
Okay.
Continuing guarantee, if assuming there is three, I'll give you an example. There is a recovery certificate. Okay. After issuance of recovery certificate, the guarantors will come and submit an OTS saying that no, I want to clear the dues. Now that will extend the limitation.
That is acknowledgement of date, sir.
The acknowledgement of date under Section 18 of Limitation Act. Or certain amounts are paid under part payments are made. That can be taken as extension of limitation. But if there is no acknowledgement, then we have to stick to 3 years. Beyond 3 years, it will not. The application is not maintainable.
Okay, sir. Thank you.
Can I ask you a question? Hello?
Yeah, please.
Hello? Yeah, actually, if you see the guarantee agreement, there is nothing mentioned that there should be a recall notice. Rather, it is mentioned that on demand you have to pay this money.
Correct.
So on demand, I can issue the Form B, isn't it?
No, that is what. That judgment, there's a recent judgment of Honorable NCLT which says that Form B cannot be considered to be a recall notice.
Now, even if it is not mentioned in the guarantee agreement.
No. What happens is, in the guarantee agreement, it very clearly says that the guarantee amount is to be paid on demand. So how do you raise a demand? How do you raise a demand? The demand is usually raised by issuing a notice.
Okay.
Otherwise, there cannot be any oral demand. The demand is usually they basically, once the account slips into NPA or there is a default, then they say there is a default, you come and pay the amounts.
Another point I have, what's happened when when the claims
to mute themselves. There's a disturbance.
Can it be muted? I mean, lots of disturbance.
Madan sir,
I have another point.
Janvi, from whom the disturbance is coming, can you ask them to put their hands, because I'm unable to do it.
Madam, you can mute them.
Madan Lal Agarwal.
Hello.
Hello, Mr. Madan, sir.
Yes, sir. I have a question regarding repayment plan approval. In one particular case, there are three financial creditor. One financial creditor holding 41% voting share, and two other 59%. All the three financial creditors appeared at the meeting where repayment plan is approved. Later on, it was done through voting through votes, wherein two financial creditors approved the same, and the one financial creditor dissent. He did not even reject or approve it. He just dissent. Will it be considered as approved or not approved?
No, if they're abstained for it, you can just assume that their voting can be excluded. They have not approved it or rejected, either rejected it. You can consider the remaining voting because they've abstained from it.
Yes, they have abstained from it.
Yeah.
Okay, thank you, sir.
I have another point, please.
Yes, sir.
You know what's happened while RP invited claim from the financial creditor. One secured financial creditor submitted its claim, but they didn't relinquish their interest, security interest. So RP included their name in the list without any voting power. But subsequently, that secured financial creditor assigned their claim to third party. So can that third party now claim that we are unsecured creditors?
No, see, what remains is once you have not relinquished it, your status will remain same.
Absolutely. I mean, even if it is assigned, that status will remain the same.
Status will remain the same. As far as IBC proceedings are concerned, they have to either relinquish or not relinquish. Subsequent to assignment, if they have come to you saying that no, we don't want to be outside, we want to be part of this, then that's a different interpretation altogether.
Thank you. Thank you.
So, any more questions from the participants, or otherwise, Janvi, there are two questions in the chat box. One is from Parth Kamal Sen, sir.
Answered, it is answered.
Okay.
Yes.
It is answered. Just
Other
now,
one
I
is
answered.
from- Thank you. The other one from Shekhar Sen Gupta, sir. So it's again the application under section 95 is filed after 3 years of the date of demand notice. Will it come under the ambit of limitation? And if yes, is there any way to overcome it?
No, I've already answered this if I'm
Yes,
not wrong.
you have answered.
Yeah.
Yeah. So any further questions from the participants? So if there are no further questions, I would like to thank Yashwardhan. Thank you, Mr. Yashwardhan, for taking
Thank you.
time and sharing your knowledge and your practical experience on the personal insolvency aspects. And also you have taken us through the latest judgments and also explained what is
Madam, can you share the PPTs? PPTs.
Yeah.
Madam,
Yeah,
PPTs share, madam.
we will share the PPT, sir. Yes, sir. We'll
Okay, madam. Affidavit also. Affidavit.
share.
Discussion paper
Discussion
that
paper.
we can get from portal.
Oh, okay. Enough. Thank you.
Paper fine. Personal insolvency we will share. So
Okay.
thank you, Yashwardhan, for explaining us what is the proportionality test and what is the threefold test, and also the Supreme Court precedent in this regard, the RP report. And thanks for answering the practical issues faced by the insolvency professionals in the personal insolvency process.
Thank you.
We'll share a memento to you. Thank you.
Thank you. It's a pleasure. It's always a pleasure. Thank you very much for giving me this opportunity.
Yeah.
Thank you, sir. Thank you, ma'am.
Thank
If
you.
you have time, you may continue. We will be discussing on the recent
Sure.
IBBI
Sure,
paper.
sure.
Otherwise,
Sure.
if you have any hearing, you can.
Thank you.
Thank you very much for your valuable time.
Thank you. Pleasure is all mine. Thank you.
Okay. So we were discussing about the recent discussion papers on issued by IBBI regarding the beneficial ownership, as well as the regarding the proposed amendments in the valuation. So we can take 10-15 minutes if members want to share their insights, so that we can collate all the suggestions and we can take this forward to the IBBI, or the comments can be submitted individually also. So the IBBI is making significant changes in the important process related aspects, and also the compliance related aspects of the IBC processes, CIRP, liquidation, and the latest one which is issued yesterday regarding the valuation also. The IBBI is proposing for the amendment for the only restricting only one valuer valuation report for the small companies, then amendment in the fair value, and also they are proposing for the coordinator between, when there are two valuations, if there is a difference, they are trying to appoint one as a coordinator who would be submitting the valuation, and the applicable provisions, that is the valuation rules and regulations prescribed under Companies Act. Now IBBI wants to bring in a unified regulations wherein they are going to prescribe a standard format for reporting the valuation, because the last 10 years, they have seen there are significant issues regarding the issue of valuation reports by different valuers. So they want to have a unified format for the valuation reports also. And regarding the other discussion paper on the submission of beneficial ownership declarations by the prospective resolution applicant and the affidavits. If you have any comments, you can share us. We will be submitting to IBBI on behalf of the IPs, or otherwise individually it can be submitted. The timeline given is up to I'll just check. It is given up to 16th December. Sorry. So any questions? Any suggestions regarding the discussion papers issued by the IBBI? Yes, ma'am. Okay. Okay, so if there are no suggestions or any issues which the participants want to discuss, otherwise, I would like to conclude that we have discussed the proposed IBBI paper, and also we had an excellent presentation from the advocate, Mr. Yashwardhan, on the practical aspects and issues about the RP report under personal insolvency. Now, we will have the IPNet West webinar, which is proposed for next week, and the topic would be shared shortly by the IPNet in the various IP groups. Now I request Mr. Shawant to kindly give his vote of thanks.
Thank you, ma'am. Thanks for sharing your thoughts on discussion paper, and also great thanks to Mr. Yaswardhan. I think he has already left for sharing his practical knowledge on the topic assigned today. So it is, I would like to proceed ahead with the vote of thanks. It is an honor to extend the vote of thanks for today's webinar. Today's event has been a good learning experience for all of us so far regarding effective handling of PIRP and latest IBBI discussion papers. First and foremost, I extend my heartfelt thanks to our distinguished speaker, Mr. Yashwardhan and Ms. Suhasini Ashok ma'am, who is also the moderator and the organizer for this session, for sharing their profound insight on the topic PIRP effectively latest IBBI discussion paper. Thank you, Yashwardhan sir, and Suhasini ma'am, for sharing your time, wisdom, and experience with us. I would like to express my gratitude to our IPNet President, Mr. Ashish Makhija sir. Sir, your commitment and visionary leadership have made IPNet an exemplary initiatives and a platform of great significance for insolvency professionals pan-India. Thank you for being a guiding light to all of us. A special note of appreciation goes to IPNet South for successful smooth conduct of this webinar. Special thanks to the invaluable contributions of transition and the technical support team. Their seamless coordination and tireless efforts behind the scenes ensured smooth conduct of webinar. Our gratitude to all the participants who have joined today. Your enthusiasm, active engagements, and thought-provoking contributions have truly made this event special. And last but not the least, our sincere thanks to Suhasini ma'am and IPNet South uh, for taking out time for from her ongoing course for ensuring the success of this webinar. Thank you to all once again. Thank you very much. Thanks from the core of heart for joining the sessions on Saturday. Thank you.
Thank you, everyone.